Gotcha.
Schedule 19 on a special election. Got our money problems right in hand. Dropping them limits like a hot potato. 50 down to 30. Oh man, wait our gun, wait our gun. I'm making money and I'm having fun with my radar gun, radar gun. With my brand new radar gun. Brand new shiny Simmons radar gun. Me and my partner go patrol car cruising on the parking lots at the shopping malls. Scanning those dashes, those mirrors and visors. The little detectors that ruin it all. Johnny caught one on an 86 T-Bird. Pull up slow just as close as I can. Milliwatt seconds on maximum output. We'll dust that puppy with one small blast of my radar gun, radar gun. I'm making money and I'm having fun with my radar gun.
Greetings, everybody. I'm Pastor Rick Strawcutter, and you've got a videotape that's called How Any Idiot Can Beat a Radar Speeding Ticket. Now, I'll leave it up to you to decide who the idiot, the real idiot is. Now, some people are going to say that it's me. I will tell you this. There are folks that are going to say, what in the world is a preacher doing a videotape showing people how to, quote, beat radar speeding tickets? Lord have mercy, what are we coming to? This man needs to be preaching the gospel, not teaching people how to beat radar speeding tickets. This guy's got to be out to lunch, a weirdo of some kind. I'm not going to deny that I am not your garden variety preacher. I am a little different, to say the least. But I haven't desired to be different. I'm just, God made me this way. This is the way I am. And I find myself, quite frankly, in some weird situations sometimes. But through it all, as I look back, God's been in it. And I honestly believe that I can show you how to defend yourself against the little beast called the radar gun, the speed meter, and at the same time help liberate you and really do a Christian service. Now, and let me explain something. Let me apologize a little bit about the title, okay? I am not suggesting beating radar speeding tickets in the sense of you beating somebody out of something that you owe a duty or you owe something to. Some folks are of the opinion that if you play, you should pay. If you go 65 in a 55 zone and you get pulled over, hey, pay your ticket and like it. Well, that's just fine. For those who are of a slave kind of mentality, where the master pulls the buckboard over and decides to whip and beat the slave for driving the horses furiously. I don't happen to be a slave, and that's not part of my mental makeup, and is probably not part of yours either. Although that's not really the only reason that I've made kind of a hobby or specialty of fighting radar speeding tickets. But first and foremost, to me, it's taxation without representation. And I'll tell you something. This whole scam of traffic enforcement through radar and speeding doesn't do one thing to make the streets safer. If you didn't have such a thing as radar speeding tickets and speed, violations altogether, it wouldn't change the outcome of fatalities per year, and people are not going to go out there and drive like crazy. Most people are reasonable people. They drive reasonably and prudently for the conditions. If conditions dictate that 90 miles an hour is safe going down a superhighway and there's very little traffic, people may tend to drive 85, 90 miles an hour. There's to be a lot of people who don't. And if conditions dictate that it's raining or snowing or whatever, reasonable, prudent drivers are going to automatically slow down. They don't need Big Brother to tell them to. There is a reasonableness that I find that is just inherent in mature, intelligent people. Why then are there speeding tickets? There are speeding regulations really for one reason only. The state makes a lot of money. Billions of dollars. In fact, in the Ferenczi case here, and we'll get to the Ferenczi case probably in a few minutes, the judge makes reference to that fact. I am opposed, personally, And I don't want anybody to think that I'm opposed to police officers. I love police officers. Some of my dearest friends are police officers. And I respect the job that they do and the fact they risk their lives and they hardly get paid a pittance of what they're worth. I mean, I wouldn't risk my life the way they do for what they do. I mean, it must be a sense of duty or a calling from God or something. I appreciate what they do. I don't want my police officers, though, being used by the government as a taxing agency. I don't want them going out imposing taxes, pulling people over their little red lights and walking out the window and say, hello, good afternoon, sir. You have been selected by the state to pay taxes today. And then arbitrarily sock you with a fine and you have to pay your $50 for it. It's taxation without representation. I went to trial one time and I saw the police officer outside the courtroom and I walked out. I told him, hey, how you doing? Shook his hand. I said, nice to see you today. I said, I want you to know that just because I'm fighting a speeding ticket, it's nothing personal between you and me. I mean, I like you personally, but I'm opposed to taxation without representation, and that's why I fight the radar ticket. And he looked at me, okay, taxation? Yeah, that's right. Taxation without representation. That's why I fight these things. And secondly, I find, one of the reasons I've made this tape, I find that there are a lot of people today in the Patriot community and just across the country, people are more likely to be litigated. They're more likely to find themselves a defendant in some kind of a trial. And they don't have any trial experience. They don't have any real legal background. I know people who are setting themselves up for battle royal with the Internal Revenue Service, for instance, and they've never so much as fought a parking ticket or a speeding ticket. Never been to trial over anything. And they're going up against the federal government, the Internal Revenue Service. Possibility of prison. With no experience. Bad deal. Friend, you need to learn how to swim in the shallow end of the pool first. Then jump into the deep end. Okay, you fight some speeding tickets. You're going to get a lot of good trial experience. You get your feet wet. Win, lose, or draw, you're going to get more than $50 worth out of this. And incidentally, if the fine on the speeding ticket is $50, okay, you are already paying a court fee that you have a right to go into that trial and have your day in court. So it's $50 if you pay it up front. It's $50 if you're found guilty in the end. But I have found over the years I have gained an awful lot of good practical experience about trial procedure and so on that to me it's just invaluable. A whole lot cheaper than law school. And I do have a year of law school. Some will wonder, well, what kind of credentials do you have? They're really concerned about this credentials thing. First of all, let me tell you something. The practice law is extremely overrated. Extremely overrated. Anybody who can walk and chew gum at the same time and can read and write the English language and do a decent job of expressing your thoughts can represent yourself in most any kind of case. And, it's just people are kind of dumbfounded by the legal mumbo-jumbo that surrounds the courtroom and a kind of a facade of, legal voodoo that they try to practice within the courtrooms. We call it a bench bar monopoly. Only the attorneys know, only the judges, only people with law degrees have brains enough to do what they do. Oh, gosh. Believe me, you can do this stuff. That's why I say any idiot can beat a radar speeding ticket. Maybe not the first time, but if you work at this, you will be able to do this, and you'll do it consistently, too. But people need to get some experience. And it just scares me to death to think there are some people who are facing real legal jeopardy, and they've never even been to trial on a speeding ticket. Just worries me. Well, okay, so I'm a pastor. I pastor the Church of the Lord Jesus Christ right here at Adrian, Michigan. By the way, this tape's being made on April 29th, 1996. And the Lord has not come yet, but we are expecting events to move that direction. And I'm excited about what the Lord is doing, to tell you the truth. And as bizarre as it sounds, the more that I help people with their problems and help them understand how the legal procedure works, and just helping people entry level. Okay, now there's plenty of guys out there that can teach a lot about common law, and they've got a lot of legal theories about dropping out of the system and all this kind of stuff, and this is fine. I understand all those legal theories. I can argue those theories, but there's very little out there that is real entry level. You know, I'm not suggesting that you tear up your driver's license and drive without a license. However, I have full respect for people who want to do that. This videotape is not, the scope of this tape is for those who do have driver's licenses and who wish to get some experience in the courtroom and would like to win some speeding tickets to start with. In this whole Patriot movement, there's a lot of books, there's a lot of tapes that are real heavy and real meaty. But frankly, I don't find a lot of stuff that is entry level. This is what this tape's all about. I mean, so if you're a legal whiz-bang already, you know, you may not get too much out of this tape. This tape is produced for Joe and Sally Six-Pack that are out there, just like a lot of us. When we knew something was wrong with the system, but we didn't know how to kind of get our hands up. But we wanted to learn. But, you know, the average guy is just not ready to tear up his driver's license, birth certificate, and rescind all of his contracts with the state and go on out there and whip out his sword and say, okay, baby, where are you coming from next? They're just not ready to go into that kind of jeopardy. Now, they might be later on. But this is entry level here, what we're talking about, and believe it'll be helpful. Okay, well, anyway, I started to tell you, I do have a year of law school. I studied torts, contracts, criminal law, and legal writing expression, all the basic first year law courses. And, in fact, I'm still registered with the California Committee of Bar Examiners as a law student. Whoop-de-doo. And I'm also a certified paralegal with specialty in civil procedure. Whoop-de-doo. I just say that because that satisfies some people because they, okay, well, then maybe he knows what he's talking about. Tell you what, degrees and all that stuff don't mean too much. Remember, I told you, if you can walk and chew gum at the same time, you can do this. You can read and write and basically express your thoughts. You've got an average intelligence, somewhere around the idiot range. You can do this, all right? How any idiot can beat a radar speed. I'll tell you what. Let me tell you how I kind of got started in some of this. I'm one of these people who knew there was something wrong with the system all along, but didn't know quite what it was. I got pulled over one time in the early days for my license plate being expired on my van. We were on our way to the Ford Museum. We were going to have a nice day with our family and going to have a good time together. And this state trooper pulls me over, and boy, I'll tell you, he was a mean dude. He came up to the car and he says, want to see your driver's license, proof of insurance, and registration. So I just said, officer, first of all, what is the probable cause for your stop? Whoa, he got mad. He said, I want your driver's license and I want it now. I said, hold it, sir. I just asked you, what is the probable cause for your stop? You tell me what the probable cause is. Maybe I'll give you my driver's license. He said, you give me that driver's license right now. And he kind of rested his hand on his pistol and in the area of his handcuffs. I looked at this dude and I thought, whoa, you know, I've hit his hot button right off the bat. I mean, he's either going to kill me or he's going to pull his gun out, and I don't know what he's going to do. I was really a little bit nervous at that point. My two children, 7 and 5 years old, were crying. My wife's about in tears. They're wondering, dear Lord, have mercy. I mean, we're in the United States of America, aren't we? Isn't this the land of the free, the home of the brave? What's going on? My husband's about to be shot over a probable cause issue with a police officer. Well, as it turned out, make a long story short, my license plate was expired, and in Michigan, it's a criminal misdemeanor. And so, you know, I got a hearing day. I got to be arraigned, you know. And so I go down there and for my arraignment date, and there was 6 or 7 guys ahead of me. They were drunk drivers. And the judge was arraigning these guys all in mass. And she said, she read their rights, 7 basic rights that they read. You have a right to plead guilty, not guilty. You have a right to trial by jury. You have a right to have an attorney. If you can't afford one, be appointed. You know the routine. And so she reads these, and then she asks them the question, Mr. Jones, do you understand your rights? And Mr. Jones says, yeah, he understands his rights. How about you, Mr. Stevens, do you understand your rights? Oh, yeah, I understand my rights. Go ahead. And then she asks him to plead guilty, not guilty, and do the whole deal. And I'm thinking to myself, these guys haven't been to law school. How can they possibly know their rights? I mean, the state's got a gimmick here. They got a noose. In order to get these people into the noose, these people have got to make voluntary admissions and confessions about things in order to get into the system. So I said to myself, I wonder what happens if I tell them I don't understand my rights. So when it came time to arraign me, she says, Mr. Strawcutter, this is the case of the people of the state of Michigan versus Rick Strawcutter, expired license plate, blah, 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 blah. She said, Mr. Strawcutter, do you understand your rights? And I said, My rights? What rights are those, Your Honor? She said, the rights that I read 5 minutes ago in this open court, you heard them. Do you understand them? I said, well, Your Honor, you only read 7 rights, and my understanding is I have over 600 rights as an American citizen. Just answer my question. Do you or do you not understand your rights? I said, well, Your Honor, I just told you no, I don't think I do, Your Honor. I don't believe I do. She said, well, then very well. The bailiff will bring you this sheet of paper, and you'll read them, and I'll be back in 5 minutes, and we'll find out if you understand your rights. Boom. Her veins were pulsating in her neck. She stormed off that bench. Man, she was mad. I thought, well, this is really interesting. You know, all this is coming down, and honestly, my pulse rate didn't increase one iota. I thought to myself, just how is it that I find myself in so many of these bizarre situations like this? All because I just said I don't understand my rights. She comes back. She's talking, have you read the sheet of paper I gave you? I said, yeah, I read portions of this. Yes. She says, specifically the portions entailing your rights. Do you or do you not understand those rights? I said, Your Honor, first of all, I want the record to clearly show that I am not an attorney. I am not represented by any counsel. And I wish to tell you that I do not understand my rights, evidently. She says, all right, we'll do them one at a time. She said, first of all, do you understand that you have a right to plead guilty or not guilty to these charges? I said, well, Your Honor, I believe I also have a right to stand mute. She said, just answer my question. Did I also have a right to stand mute? Well, we went around and around on this issue for about 5 minutes. In fact, in the official transcript, I include this transcript as part of the paperwork package that goes with this videotape. I don't know if you got the paperwork or not, but anyway, there's a paperwork package that goes with it. And she says, the transcript just says individual conversation follows, or simultaneous conversation follows. Evidently, the person transcribing it could not sort out what she was saying, what I was saying, because we were both talking at the same time, I guess. So finally, she says, oh, all right. I said, all right, what? She said, do you agree that, or do you understand that you have a right to plead guilty or not guilty or stand mute? I said, yeah, I understand. Do you understand that you have a right to have a trial by jury or you can have a trial by the bench? I said, Your Honor, is it necessary and imperative that I answer these questions? She said, yes, it is. I said, well, why is it? Well, she said, because if you don't understand your rights, then you're not competent to stand trial. I thought, well, that's what I'm after. I don't want to stand trial. I don't want to be here. Well, Your Honor, then I don't understand my rights, and furthermore, I'm not an attorney, and I don't have counsel. And you're asking me leading and intimidating and incriminating questions for which I don't believe I can answer. Do you understand that you have a right to be represented by an attorney if you can't afford an attorney, da-da-da-da-da? Do you understand that? I said, Your Honor, I'm not an attorney. I don't have counsel. You're asking me an incriminating question. I must say, I do not understand this right. She says, do you understand that you have a right to, whatever they were, 4 or 5 of these things. Every one of them I just said, I'm not an attorney. Don't have counsel. Don't understand. So she got down there and she said, okay, very well, because you've unequivocally told this court that you do not understand such simple things as to plead guilty or not guilty. I'm going to hold you in lieu of $500 cash bond. Ooh, immediately I realized, I'm in a bit of trouble. She's going to seize me and not let me go. So I said, objection, Your Honor. Because you're unable to understand these rights, I'm going to order you to the forensics center in Ypsilanti. That's a nut house. I call the story the Natalie or the Nut House story because the judge's name was Natalie Kaselka. The nut house is where she wanted to put me. And I mean, but this is a very tense situation. She said, because to determine if you're able to understand the legal processes and stand trial. Man, the gavel hit, and she got up, she walked off, and 2 police officers were headed for me. And they placed me in custody. When that happened, ladies and gentlemen, it's a miracle. I didn't get shook one bit. I just thought, this is just very interesting. The Spirit of the Lord spoke to me and said, Antichrist is not coming. Antichrist just got off the bench. Now, the way I understand what the Lord spoke to me, it's not that woman judge, she's not the Antichrist of the Bible, but the Antichrist is an alternate God from Jesus Christ. It's the state. It's the collective force and power of people who have a system that operates with total disregard for God and His law and His system of values. That was my first real introduction that, hey, Christian religion is more than pie in the sky and the sweet by and by. Well, we don't have to worry about demons and devils that are going around in invisible places, little spooks that hide behind quarters. There's demons and devils that are walking around three-piece suits that carry attaché cases, that vote, that have power, that control the gun barrel of government. You want to look for the power of Antichrist? Look no farther than the system that's probably just around the corner in your little downtown. Well, they put me back in a holding cell, and I was sitting there thinking, hey, you know, this is, remember the TV show The Life of Riley? Some of you older guys, you know, what was that guy's name? I forget now. Anyhow, he was always saying, this is a fine predicament you got me. You know, I think to myself, oh, it's a fine predicament I got myself in it. Because my wife was in Louisiana at the time, and my children, I have 2 children, they're going to be getting out of school in, you know, like an hour. And if these guys figure out my wife's out of town and I'm in custody going to a nut house, my kids will end up in protective custody. And then we got real problems, you know. So I thought, I got to get out of this somehow. What am I going to do? Well, a friend of mine is an attorney, happened to be at the courthouse. And within a matter of minutes, he came down to this holding area, and he came inside, and he closes the door, and he makes sure this is kind of a soundproof room. He closes the door, and he says to me, he says, man, what did you do to the judge? I said, why? Is she upset? He said, is she upset? He said, I have never. She's trembling. She grabbed me by the lapels and said, do you want to represent somebody today? And he said, well, I don't know what's going on. She said, oh, I got Reverend Strawcutter down here. He says he doesn't understand his rights. She said, I'm going to send him to the nut house if he doesn't straighten up. So I told my friend exactly what had happened. This friend, by the way, eventually became a circuit court judge, and he is the best. I don't mind telling you that Tim Pickard is the finest, most honorable judge in this county. The other judges, very questionable, but Tim Pickard is worthy of the appellate, the honorable. As far as I'm concerned, he's a good guy. He's honest. He's just. What I'll tell you. Now there are some judges like that in the country. You know, don't get the idea that all judges are crooks and gangsters and all attorneys are scumbags. That's just not true. But anyway, Tim came in and he says, "Well," he said, "I'll tell you, she's going to send you to the forensic center." And he said, "I can't see this." He said, "Why don't I represent you for just this phase of the process?" He said, "And I can have you on your way in about 5 minutes." And I told him about my kids and my wife being out of town. So I capitulated. I said, okay, I've learned my lesson. I've learned something here today. I'm getting an insight. I think every time you do anything, any day of your life, you ought to learn something. I'm learning something. So I'll go back to the courtroom. And we did the whole thing over as if nothing had ever happened. It was amazing how this system is so flexible. It can correct anything it wants to correct. She said, this is the case, State of Michigan versus Rick Strawcutter, blah, blah, blah. My attorney stood. He says, Your Honor, I have talked to my client, and he indicates that he does understand these rights. There was some confusion before. He understands them at this time. So then she turned to me and says, okay, Mr. Strawcutter, do you understand these rights? And I'll tell you what, I got this feeling coming on me, and I thought to myself, oh no, I'm going to do this again. I mean, am I going to bend over, or am I going to stand upright? I did a combination of the two, I guess. I said, these rights? Sure, I understand these rights. And she said, very well, give you a PR bond, and you're on your way. Have a nice day. And then we had a complete jury trial on the whole issue and all that, but that's not for this thing. But I'm telling you a little bit about where I'm coming from as a preacher and why I do some of the weird stuff I do. Okay, I've been involved in I got involved in a near riot. We had an issue come down in our community, and there were 500 people. We had a protest and a counter-protest, a bunch of against a homosexual situation in our community. Some people called ACT UP came to our town, disgusting bunch of perverts and their antics. So I organized a counter-protest and eventually got to where we had 500 people downtown one Saturday, near riot proportion. The police lost complete control of the situation. I ended up on Donahue things. So, more than once I've been catapulted into some national situations. I used to have a late-night talk show called The Last Straw with Rick Strawcutter. We founded our own radio station, which is up and going now, and it's called WRFL. It's a complete unlicensed radio station. We're doing it pursuant to our rights under the Constitution and common law, and that's another subject, too. But anyway, we've done a lot of weird stuff, and I don't know why. I do not know why, ladies and gentlemen. Why it is that my life seems to go in a flow and a stream that takes me in some very strange directions, but it just does. And I'm doing this tape now, how any idiot can beat a radar speeding ticket. I hope it's helpful. I hope you don't mind my kind of rambling on here and giving you maybe some background information so you can understand me a little better and understand why a pastor is teaching this stuff. Believe me, I do not advocate that people wantonly disregard the unreasonable human risk to other people in your driving habits. I'm not trying to show people how to, quote, beat the system for the sake of just getting away with something. I feel very strongly about the fact that Hosea said, my people are destroyed for lack of knowledge. I'm going to tell you, this country is in a sad shape it's in today because people don't know. They don't know what in the world is going on or what's coming down around them. And if they can start by learning how to defend themselves against a speeding ticket, well, then maybe 1 by 1, 2 by 2, 10 by 10, 1,000 by 1,000, we can start getting enough upstairs here where we can really understand what's going on in the economy of the country, our whole educational, political situation. I think part of it begins with the kind of thing we're doing here right now. Now, so the scope of this thing is entry level. It's trying to teach you something about the legal processes and how to represent yourself. Get away from these attorneys. You don't have to pay these jokers. Believe me, at least 40 to 50% of these guys are incompetent. Really. In fact, the U.S. Supreme Court Justice Berger said that 85% of trial attorneys were incompetent in his judgment. This is not a jurisdictional thing, too. I'm not approaching this from the standpoint of, getting rid of your driver's license and dropping out of the system and fighting it on jurisdictional grounds. I am fully familiar with those arguments, and I support them if you want to make them. I'm familiar with traveling as a matter of a constitutional right versus driving as a matter of state-sanctioned privilege. But we're not. That's not the scope of this tape. We're not exploring it in that way. Okay. Let's say you get a ticket. All right. Let's start with what I call the scene of the crime. The first contact you have, the blue lights or red lights or whatever, they're going off. Cop's got you pulled over. He walks up. You roll down the window. He's going to say something. You're going to say something. It will be very important, ladies and gentlemen, that you do not say anything. All right? You have a right. Part of free speech is the right not to speak. You never, ever, under any circumstances, have to answer a police officer any kind of question. You do not have to say anything. George Gordon's got a basic rule he calls the big three. Don't say anything. Keep your mouth shut. Shut up. Okay. Now, this is hard to get through your head sometimes because we're used to, we got this knee-jerk response that we give to police officers and other people in authority when they ask us things. We tend to herb up questions. Learn not to do it. Okay. Now, we're going to show you some videotape that we shot the other day to give you an idea how a typical stop goes and how not to do it. Okay. Now, the first thing you're going to see, this first scene, we're going to show it to you just right here directly. This is probably going to look fairly familiar to you. Results in getting a ticket. And this is how you do not want to do this. Let's go ahead and roll this. Take a look.
Can I see your driver's license, please?
Sure.
Mr. Strawcutter, were you aware the speed limit along this stretch of road is 45 miles per hour?
Yep, there's the sign right there.
You know how fast you were traveling?
Whoa! Not much over 45, I hope.
I had you on the radar as going 59 miles per hour. Does this seem about right to you?
Well, 59 miles an hour? I don't know. You know, all I know, I'm a little bit late for work, and I might have been moving along a little faster, but I don't know if I was doing 59 or not. But I am late for work.
All right, I'll be right back.
It was fun, wasn't it? And maybe you've gone through that kind of experience yourself. Notice how there were questions that were asked. Do you realize what the speed is along this street? How fast were you going? The poor guy made confessions, didn't he? He said he was in a hurry. He was late for work. Things like that. All these sort of things will be used against you in court to substantiate the fact that you were speeding, and you will be found guilty. Even if you're able to defeat the radar, your confessions of your own mouth, 80% of all criminal prosecutions begin with the admissions and confessions of the defendant. Somewhere along the line, they said something to somebody, and it became a matter of record, and it hung them. It started the prosecution, and it ultimately finished the prosecution. Don't say anything. Keep your mouth shut. Shut up. All right? Now, there's a way to do this in a legal sense, and this is the second tape we're going to show you, and you have absolute right to do this. Let's go ahead and roll this piece of tape, and then we'll analyze it. Go ahead. Hi, officer.
Could I see your driver's license, please?
Yeah, sure.
Mr. Strawcutter, were you aware the speed limit along this stretch of road is 45 miles per hour?
I respectfully decline to answer that question.
Sir, do you know how fast you were traveling?
I respectfully decline to answer that question.
I had you on the radar as going 59 miles per hour. Does this seem about right to you?
I respectfully decline to answer that question.
Do you intend on answering any of my questions?
I respectfully decline to answer that question as well.
All right, I'll be right back.
Okay, now notice, a little different situation, right? First of all, had a tape recorder out. Let me tell you something. For $39, I bought expensive tape recorders before, and they tear up. But for $39, man, these things, I've dropped this on cement. They're tough. It is a very valuable investment to make. Pull that tape recorder out and hold it up so the police officer, I generally have this out there openly, just like I did in the videotape. I want the officer to know that I'm taping the conversation. It helps in some ways. Now, you take out a tape recorder, you got about a 40% chance you're not going to get a ticket, simply because the officer may be thrown off by the idea that you are taping him, and he may not know exactly what's coming down. But I have this tape out because I want to preserve the record. If he gets on the witness stand in the trial and tries to say that I made admissions about driving fast or being in a hurry or anything like that that would tend to incriminate me, no way. I'm going to prove that guy. I'm going to impeach him as a liar with my tape. Okay? So I put the tape out there to put him on notice that I'm recording the conversation. Any question he asks me is to elicit incriminating statements. So therefore, I simply decline to answer every single question. Practice this in front of a mirror if you have to. Practice it so that you will do it no matter what kind of contact you have with a law enforcement individual. Certainly there are times in which you will talk to police and you will, if there's, I don't know what the situation might be. A child is missing in your neighborhood. Maybe you saw the child or you saw something, whatever. Obviously, if the police say, did you see anything? You're not going to say, I decline to answer, the ground may tend to incriminate. You're not going to do that. You're going to tend to be helpful, except that we've seen horror stories, haven't we? You've seen them on 2020 where people saw something or they commented on something. In fact, there was one deal where a guy had a dream about a murder, and he told the police about his dream, and that was the only lead they have, so they prosecuted him, and they convicted the guy of murder based on a dream that he had. So what I'm saying is, you're always in peril if you talk to the police. So generally I advocate that you not talk to cops. Declining to answer every single question ensures the fact that when you go to trial, the only quote, enemy you have, it's not the police officer, it is that little box that sits on his dash called a speed meter, a radar gun. That's the only issue that's going to be entered in there against you. There'll be no admissions or confessions on your part. The police officer will not be able to say, the defendant said thus. Because the defendant didn't say anything. All right? This defendant sure did not say anything, and I urge you to follow that line also. Okay? All right. Now, let me tell you, it's kind of a funny story I can tell you about this matter of keeping your mouth shut. There was a guy, oh man, this has been probably 8, 9 years ago. There was a guy that he was pulled over on suspicion of drunk driving. I mean, he was not driving too good. And the guy later admitted that he was plastered. He said he was so drunk he couldn't walk. He said that's why he was driving. If that makes any sense. But anyway, he gets pulled over, and he knows if he rolls down the window and they're going to smell alcohol, he's going to have some problems. It's going to be incriminating, right? So when the cop comes, he says, I want to see your driver's license. He gets out his driver's license, and he just held it up to the glass, like that. The cop says, no, I want to see the thing. And starts beating on the car with his flashlight and starts getting real threatening and everything, you know. So finally, the guy was afraid he was going to break his window, and so he cracked the window just enough so he could slip the license out through the top of it. Okay, so they got his driver's license. Now they said, you get out of the car. He just ignores them. He just sits there. I mean, for like 2.5, 3 hours, he just sits there. Finally, there's 4, 5, 6 squad cars around there. They're shining lights. They're banging on the doors. They're having a fit. Finally, they brought a guy that had one of these bars you put down there and opens up the door. I don't know what probable cause they had to do this kind of dynamic entry, but anyway, they did this. They open up the door. They tell the guy, now you get out. He won't get out. He goes stiff as a board, just stiff and real rigid, because he knows they want him to do one of these walking tests where you walk the line, you touch your nose and do all this stuff. He declines to do anything. He just stands rigid. He wants the record to show clearly, I never answered any questions. I didn't open my mouth. I didn't breathe on these people, and I didn't comply with any of their preliminary PPT tests, what do they call it, the preliminary intoxication tests that lead them to have probable cause to believe that you've been drinking and do other things. So he just went stiff and rigid. They pick him up like a board, put him in their squad car, take him downtown. Again, he declines to answer any questions, won't sign anything, won't do anything for these people. They say, okay, you're going to be a tough guy. All right, well, we'll put you in the tank. So they put him in the tank. 6, 7, 8 hours goes by, all right? He's had time to urinate into the urinal. And they didn't catch that urine because, you see, you got a right to your property, and it can't be seized without due process law. So any evidence they did have hours earlier is gone. These cops now have a man in custody for 8 hours who's completely sober. Had some big problems. And that guy was smart enough to sue him. Now, there used to be an attitude amongst a lot of people that somehow the system, in these cops, I realize there are some cops that are jerks, maybe they do need to be sued. We are not advocating that you take this kind of knowledge and just go out there hunting for bears. And people, one guy says, well, I'll let the government do whatever they think they can afford. Whatever. Anyway, it's just kind of a funny story. I hope you don't mind my stupid story. Do you think they like these stupid stories I tell? Are they interesting? Okay, I'm talking to my cameraman here. Okay. All right. The trial process. When you get this ticket, there's a response of some kind you make to the courthouse, and you will. They will try to give you an informal hearing. They'll try to give you a magistrate, okay? They'll say, oh, yeah, it'll just be you and the police officer and the magistrate, and you can tell your story, and he tells his story, and the magistrate decides, no. No informal hearings. Don't fall for that trap. You go in there and you demand a formal hearing before a duly elected judge, not an appointed magistrate. You want a district court judge. In our state, the lowest level of judges is district court. So you want a formal hearing. It's very important because If you lose at the first level, you've got an appeal of right guaranteed, only one. All other appeals beyond that are a matter of leave. You have to apply for leave for appeal, and you may or may not get it. All right. If you do have to appeal, you want it to go to the next higher judge. Okay, you want the highest jurisdiction you have in your county. You don't want to start out at the magistrate level and then appeal to some flunky on the district level. Okay, you want to make this your beginning as good as you possibly can. So first thing is, don't fall for the informal hearing gimmick. All right. Now, you get a formal hearing set. A good percentage of the time, the cop doesn't show up. If the police officer does not show up for the trial, you make sure you move for a dismissal, all right, in the interest of justice and due process. So, Your Honor, I'm here at the time and date set certain for this hearing. I'm here. It's not my fault that their witness is not here. In the interest of justice, I move that you dismiss. I actually had a trial one time where the cop didn't show up. I had to drive 50 miles to go to the trial. The cop didn't show up. And the judge actually equivocated for a while. I thought, well, maybe he would adjourn and have another hearing another date. I said, that's just plain unfair, and that is not equal. That's not equal protection under the law. I've come 50 miles here one way to have this trial. He's not here. Justice demands it be dismissed. Well, finally he agreed with me and dismissed it. And most of the time they will dismiss if the cop doesn't show up. But I just mentioned this. Don't let the judge pull you into an adjournment without your objection and move you on to another time for the trial. Because what we're into here is winning. Okay, we're going to take a TKO any way we can get it. You don't necessarily have to go the distance in the fight. If you can get this thing knocked out early on, then that's what you want to do it. Now, you are most likely going to be tried in an equity court. This is a civil matter. Okay, it's not criminal. Now, the standard of proof in a civil matter is the preponderance of the evidence. What that means is that the people of your state or the city or the whatever your opponent, that entity that's trying to get $50 of your money, whatever the fine is, those people have to establish the evidence to a standard called the preponderance of the evidence. Now, what does this mean? Well, just view a teeter-totter or a scale or a balance, okay? Whatever will cause that scale to tip just ever so slightly in favor of one side or the other. That is the preponderance. It's something more than 50%. Now, a more strict standard is called clear and convincing. But that is the second highest standard. And the third highest standard is in the criminal trial. You must be convicted with evidence that the weight of the witness, the evidence, is beyond reasonable doubt. That's a real tilt of the scale. The strongest, strictest is beyond reasonable doubt, clear and convincing, and then just slightly more than 50% is called the preponderance of the evidence. So they don't have to prove a whole lot. You just have to establish some evidence that tips the scales. What to expect when you come to the trial? All right, when you go to the trial, the judge is going to call the case, and you'll hear the judge say something to the effect, this is the case of the state of XYZ versus Joe Dokes, and the prosecutions are here, so the judge will say to the prosecutor, are the people or the state, are you ready to move forward? And they will say, yes, we are, Your Honor. And then they'll turn to the defendant, that's you, and they'll say, are you ready? And you will either say, yes, I am, or you'll do like I do. I'm going to share something here. This is kind of deviating it just a slight bit from the plan, but I think I should share this with you. What I do is I say, well, Your Honor, I have a procedural matter I need to take up with the court before I'm ready to move forward. And they'll say, and what is that? And then I need to find my driver's license. Here we go. Your Honor, I wish to challenge the jurisdiction of this court today over this person, that's me, because I am not a licensed driver. And I present my license as evidence, and I also Xerox this off. And I don't think you can see this. Anyway, it's not all that, I don't know, You might be able to see that. Can you get in tight on that? You see where I've signed this? There we go. See where I have signed this? The fact, without prejudice, 1-207 UCC. The reason I did that is, and I tell the court, Your Honor, I wish to travel on the roads and highways as a matter of my constitutionally guaranteed right to travel. I don't wish to be in a regulated enterprise. I'm not in trade and commerce and industry. I don't want a driver's license. I want to travel as a matter of constitutional right and not state-regulated privilege. But these guys over here, they insist that if I don't have one of these things, that they're going to pull me over from time to time. They're going to hurt me. If I don't have one of these little pieces of paper, they're going to inflict some damage on me. And I don't want to be damaged. I don't want to be hurt. So, under duress, under threat, out of coercion, Your Honor, I put my signature on there, but I've made a specific reservation right here that I'm not a party to unrevealed contracts, and I'm not a party to this contract. Now, there may be people who willingly volunteer into this, but I'm not willingly volunteering. Therefore, my signature is not valid here. It was obtained under threat and duress, and I am not a licensed driver. And so the judge, the first time they hear this, they're really kind of curious about it, because they've never heard this kind of stuff before. I'm going to tell you what, it's amazing how enslaved even the people who are doing the enslaving, how enslaved their minds are. They've not even thought about some of this stuff, really. And so they'll ask the other side, well, do you have any response to this? And most of the time the prosecutor just says, no, not really, Your Honor. And then the judge will say, well, I'm going to overrule your objection, Mr. Strawcutter. I'm finding that there is jurisdiction, and we're just going to move forward. I say, well, but I wish to make an objection, and that objection be noted on the record. What I've done is I have preserved my jurisdictional argument. Jurisdiction can be raised at any time, and it may come a time when I will raise this in order to win my case. Now, I have found that I have never won based on this issue of the reservation of rights on the driver's license. However, I consistently win on other grounds that just kind of coincidentally happened on the same day that I raised this driver's license issue. So I think there is something there. For whatever it's worth, I offer that to you. Okay. So they overrule that, and then the judge turns to the prosecution, and they say, you may call your first witness, and they do. They call the police officer. I've never seen a speeding trial yet where they called more than one witness. It's always just the police officer. Could be an exception someday, but just the police officer. He gets up, and they ask him questions. And when they get through asking him questions, then it's my turn, or in your case, when you do it, it's your turn. You can then ask them a question, and it's called cross-examination. When the state examines their own witness, it's called direct examination. When you do, it's called cross-examination. And the purpose for cross-examination is to try and impeach what they have said and weaken it, okay? Then they have an option to redirect and ask more questions if they want, and you can also re-cross-examination. And then at the end of that, the judge will ask them, are there any more questions? The prosecution will more than likely say no. And then that witness then steps down. Then they'll ask, do you have any other witnesses? And they'll say no. And then they say the neatest thing, they say the people rest. When the prosecution rests its case, it's your turn. Okay? Now the reason I say this is neat is because when they rest, they cannot go back up and open up their little box of tricks again. They put on their, what they call their prima facie case. All right? It's your turn. Now, when it's your turn, most of the time, as you're going to find out in this videotape, you're not going to put on any defense whatsoever. You're going to argue against their case right now. And it's called challenging their prima facie case. Or you may call it final argument. Either way, it doesn't matter. If you're a purist, you're challenging the prima facie case, but we're not interested in all this legal mumbo jumbo. We're interested in winning the case, right? So what you're going to do is you're going to just tell the judge, no, Your Honor, we don't have any defense to offer. I wish to challenge their prima facie case. I wish to just move to final argument right now. So just say that's fine. So they turn to the prosecutor. The prosecutor gets up and they give their argument why they believe that you're guilty. And then you have a chance to tell the judge why you believe you're not guilty or why you should not be found responsible for the speeding ticket. Then it goes back to the prosecution. They have two chances to argue. They go first, you go next, and then they get to come one more time after you. I know it doesn't sound fair. The presumption is that they've got to prove that you're presumed innocent, until proven guilty, so they get a little additional edge. I don't think it's fair, but that's the way it is. It's like Walter Cronkite used to say, that's the way it is on April 29th, 1996. And then the judge renders his or her final opinion and decision. Now, during this process of your trial, it is going to be very important that you make objections. And there'll be plenty of opportunity to make objections. And believe you me, when you first get started in this, you're going to miss a lot of good objections, simply because you're not experienced. But in time, you're going to learn how to do objections. You do objections right, and they'll help you win your case. And they've got to be timely. Let me quote you something. Here we go. This is an opinion from a case here called, get in on this, just for whatever it's worth. This is the state of, is this the people? Yeah, the people of the state of Michigan versus Strawcutter, and it is called an opinion in order by the judge. Now, the judge says some interesting stuff here. Now, this is back 1991, was it? Might be 1988. 1990 or 91. 1991 it was. About 5 years ago. This Judge Sanderson, by the way, was a good judge. I thought he was a fair and reasonable judge. In fact, he even complimented me on doing such a good job. This is back when I was losing cases. I really wasn't doing that hot. But I'm going to share something with you here that the judge said in rendering his opinion that helped me. Again, win, lose, or draw, you learn, you see. And I've spent a lot of money in these courtrooms. I've lost a bunch of cases in order to learn stuff, okay? You don't have to make the mistakes I made. I'm hoping you learn from my mistakes. Okay, that's what you're supposed to do in this videotape. All right. Here, I'm going to read directly from the paragraph, and you can follow this on your screen. In making these findings of facts and conclusions, I am not unmindful that some of the evidence relied upon was subject to a hearsay objection. It was subject to a hearsay objection. Two examples that come readily to mind are the trooper's statements regarding the January 18, 1990 certification of the radar unit and the April 18th calibration of the speedometer. No hearsay objections were raised by Mr. Strawcutter. Thus, that information is incorporated in the facts used by this court in finding by a preponderance of the evidence that Mr. Strawcutter was responsible for the speeding violation. Did you catch that? The judge was saying, if there were objections, he's saying here was where the weak link was in the state's prosecution against you, Mr. Strawcutter. They offered evidence which you could have objected to on the basis of hearsay, but you didn't do it. And I'm telling you, folks, in these little old speeding ticket trials or any other kind of trial you happen to find yourself involved in, there's going to be evidence offered that's going to be hearsay, or it's going to be conclusory, or it's going to be opinion, or it's going to be the question asked will in some way be improper. And there'll be lots of opportunities for you to say, objection, Your Honor. Question calls for hearsay. Objection, Your Honor. The answer is hearsay. Objection, Your Honor. Relevancy. Lots of them. Of course, when this first starts coming down, you're not aware of it. And it just sneaks up on you and it gets by you. And your objection has got to be timely. You can't get to thinking about this a half an hour later and say, hey, Your Honor, way back there, he has... No. You got to object timely. There's an action of law that says failure to object timely is fatal. Right? In this case, it was fatal for me. It cost me $50 worth of fatality. But I offer that to you in all humility. I mean, I'm admitting that I made mistakes. And I want you to learn from them, okay? And the judge is going to help us all learn. Now, don't be afraid to wear out these people with objections. When I say wear them out, don't hesitate right from the get-go. The first question the prosecutor may ask the police officer, Officer Jones, were you doing speed readings on M52 on this date? Objection, Your Honor. The question calls for facts that are not in evidence. Speed readings. What are speed readings? No foundation laid for that question. Don't hesitate to jump right in there and object to relevancy and object to hearsay and object to questions that assume facts not in evidence. Don't hesitate to do a lot of objecting. These people come to trial. Most of these prosecutors are not prepared. They walk up there, they look through their daily duties, say, oh, I got a speeding ticket. Oh, okay. Cop here? Okay, he's here. Who's the cop? Oh, you a new guy? Oh, nice to meet you. Okay, let's go to trial. That's about how prepared they are. And they got golfing outings they want to go to. They got cocktail parties they want to go to. They got girlfriends, boyfriends to see. They got, they want to go to lunch on time, all this kind of stuff. You go in there and you show these fellers and gals that you're not a pushover, you are prepared, and you start making objections. Even if your objections in some cases are baseless, don't worry about it. You're a non-attorney. You can't be held to the standards of an attorney. Get in there and make plenty of objections. You make these people work. They think they're going to go in there in 20 minutes, walk out with a conviction because you got some dodo. You're no dodo. You're going to have knowledge. And you're going to go in there and you're going to defend yourself. And if all you do is just frustrate the fire out of them with a lot of objections, then do that. You turn. There's a housewife over in our parts. She'd never been in court before in her life, and she basically went through the little course you're going through. She turned a speeding ticket into a 4-day trial. 4 days. Spread over 3 months, a total of 11 hours with the adjournments. They do 2 hours here and they adjourn to another day, and then they do it over and over. This lady was objecting every time they breathed. She drug the thing out, and I'll tell you what, she was found guilty in the end, but she don't get tickets no more. The state cannot justify spending thousands of dollars trying to collect $50. If you establish a history of fighting every single ticket you get, pretty soon you won't be getting them. Now, that's another way that an idiot can get out of speeding tickets. Now, I don't know if there's any truth to the allegations that some people get red flagged, some kind of a computer red flag, so that when they pull you over and they put your driver's license through the computer, that somehow it comes back and says, don't ticket this person or let them go. But I will tell you this, and this is an absolutely true story. Last year, I was driving home from Jackson, Michigan. I was on US 127. No cars in sight. I drive a vehicle. I've got a 1995 Jeep Cherokee with Michelin tires. This vehicle's capable of 120 miles an hour. I was doing 92 miles an hour on my way home. Now, I tell you that there's no other cars there, so that you'll know, I do not advocate driving in any manner that risks anyone's life, not even my own. I would not drive 92 miles an hour, be zigzagging in and out of traffic and all kinds of stuff like that. That is careless and risky, and it is an unreasonable and a wanton, willful disregard of the rights of other people to be safe and secure on the highway. Okay, I'm zooming along, and up over the hill, here comes a state trooper. And when he went by me, I thought, oh, he's going to get me. So he turns around. By the time he turns around, I got my car down to 55 miles an hour. You do not want a police officer coming from behind and pacing you. Again, that's beyond the scope of this presentation. We're talking about radar, primarily moving radar, okay? Although it works for stationary mode as well. You do not want that officer testifying that not only did he get you on radar, but he said, I followed him for 3 miles and paced him, and they were also exceeding the limit at that time. Now you got 2 witnesses against you. You got speedometer, you got visual observation, you got radar. Boom, boom, boom. They're going to get you. Difficult. I will confess you, it's difficult to defend against the pacing. There's ways to do it. It's beyond the scope of this presentation. So anyway, he pulls me over, comes up to the car, and he says, let's see your driver's license, proof of insurance. I says, sure, officer, how are you doing today? He says, good. He says, Do you understand that the speed limit along here is 55 miles an hour? I said, well, officer, I respectfully decline to answer that question. He said, all right, do you have any idea how fast you were going? I said, I must respectfully decline to answer that question as well. He said, my radar showed you doing 92 miles an hour. Does that seem accurate to you? Officer, I must respectfully decline to answer that question. Do you intend to answer any of my questions? I'm afraid I'm going to have to respectfully decline to answer that question as well, yeah, officer. With a smile on my face. You don't have to be mean and gruff about it, you know. Just smile. You know, so many people, they have a hard time saying no. You know? Well, look in the mirror sometime and just practice saying no. 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 If you still feel like it's being rude, well, try to smile and say, no. It works. Just say no. Well, the trooper went back to his car. He's gone for about 5-10 minutes. I figure he's coming back with one whale of a ticket for me. He handed me my driver's license, just said, Mr. Strawcutter, have a nice day. And he walked back to his car, and that was it. Is there something on the computer that says, don't stop Strawcutter? I don't know. Is there something that says it ain't worth it? He fights every ticket he gets? I don't know. But that happened. Incidentally, several years ago, there were so many patriots in Arizona that were making constitutional objections to being pulled over, demanding probable cause and all that kind of stuff. And then they were suing the police, and they really had something going. The Attorney General in Arizona sent a memo out to all state troopers in Arizona and told them that if you pull people over and they start making constitutional objections, demand probable cause, decline to answer, and all that kind of stuff, let them go. The state decided it is not worth it. The prosecution is not worth it. And then plus these guys are turning around, they're filing Title 42 lawsuits. And, you know, people wonder, how can we get our country back? Well, part of it is learning to say no, learning what your rights are under the Constitution, learning that this business of going to court is not that spooky. Man, I'll tell you what, we just had a few 100,000 people who had brains enough to do this stuff. I shouldn't say brains enough. Maybe we're idiotic enough to do it. You know, because in some ways you got to be just a little bit off the ball, and the bubble's just a little bit off in order to even dare to do this stuff. So many people are in this life, they're just concerned about, well, as long as I got a job, as long as I can afford a six-pack, as long as I got a patch of grass outside my house to mow, and I got my little dog Fido, and I got my cable paid for, and I got my TV, everything's just fine. That's why this country's going to hell, Jack, because we've got so many people like that. Turn that stupid tube off from the nonsense and watch stuff like we're doing here, and we'll turn you on to a whole lot more good stuff, too. This is just the beginning. This is entry level. Say that to me. Entry level. Good. Okay. Now, you want me to tell you not only these corny stories, these are all true. I mean, I'm not telling you stories just to be making jokes. This is true. This guy had been through a little basic course like this, and he had studied the question of whether, when the police officer pulls you over, is this an in-custody interrogation or are you under arrest? You see, because if a police officer stops you on the street, this happened to me before, where they say, I want to talk to you. I say, oh, I don't have time to talk right now. Good day. I just keep walking if I don't want to talk to them. There's nothing to say. I have had conversations with police officers, but if I don't want to talk to them, like I feel like maybe they want to arrest me for some reason. And down around the courthouse, we had that happen one time when we were having a protest. We were passing out flyers in the street. Police officer said, you do that anymore, I'm going to arrest you for going in the street. I just went out in the street, passed out my flyers, you know. In our town, they shut down, they don't shut down, but they hinder the flow of traffic selling peanuts. I mean, they got an extortion racket. They got some kind of, I don't know, some civic thing. What is it, Albert, they do? It's Civitan Club or something like that. And people roll down the window, and they give them a buck, and they give them a little bag of peanuts. Well, I said, man, if they can do that, I can go out there and pass out my handbills and my flyers, too. And this police officer kept wanting to talk to me. I just kept walking by. It's just, you never have to talk to police officers, okay? And, or you can ask them the question, am I under arrest? I was on trial one time for refusing to get a building permit for church parsonage. We put an addition on. I ultimately spent 13 days in jail protesting the situation, but that's another story, too. When the trial was starting, one of our men was downtown passing out jury instructions, and the cops came along and grabbed his jury instructions. Because we were trying to educate people to what the Constitution has to say about your right to decide the law as well as the facts. And this guy was just brand new to this. I mean, he was brand new in church, too. All he knew is his pastor's being prosecuted, trying to put him in jail. He wanted to help do something. Somebody gave him a bunch of jury instructions. Here, pass these things out downtown around the courthouse, and maybe one of the jurors will get it and get enlightened. So he's passing them out. He came up and he said, I was passing stuff out, and these cops took it. And he said, that's one of them right down there. And the cop said to him, says, come here, I want to see it. And I just real quickly, I told the guy, I said, just ask him, am I under arrest? That's all you ask him. Don't ask him another thing. Just say, am I under arrest? And if he's not going to tell you you're under arrest. He's going to try to get you to make a statement so he can arrest you. That's the gimmick. You just keep asking him, am I under arrest? Am I under arrest? So he went down there, and the cop said, what is your name? He says, am I under arrest? I just want to know what your name is. What's your name, guy? He said, am I under arrest? I want to know. He said, all we want to do is just identify. Do you have a driver's license? He says, am I under arrest? So the cops looked at each other, and they went through this doorway. I had a hunch he was going to talk to the judge. And my guy came back. He was shaking like a leaf. And I said, you did perfectly. I said, I suggest you just go home and get some rest before you have some kind of breakdown. But you did beautiful. Did beautiful. There are so many people that if a cop says, who are you, what's your name, give me your driver's license, for anything, they'll say, oh, yes, officer. Yes, certainly. Don't have to do it. Do not have to. Anyway, where are we? Are we having any fun yet? Let's talk a little bit about the objections. Some of the most popular objections, there's at least a dozen of them you can make, but the most popular ones that you're going to practically be able to make during the trial is objection, Your Honor, relevancy. Anytime in the trial process, if you say the word objection, it's like timeout in a sports event. It stops. Everything stops. Sometimes I've objected to things simply because I need a little bit of time to make a note or something. Maybe the prosecutor's going too fast, and I just say, objection, Your Honor, relevancy. They're asking a question, maybe it's entirely irrelevant. It don't matter. I need time. And the judge will say, overrule, and they go on. But it gives me a little break, a little space of time. Get used to saying objection. Practice that one in front of the mirror, too. Objection, objection, objection. That will get you some time. Objection, Your Honor. The question assumes facts that are not in evidence. That's a good one. We'll talk a little bit more about these objections and the practical application of them a little bit later on. Objection, Your Honor. The question calls for a conclusion of law. Witnesses can testify as to what they know and what they see and what's happened that they have personal knowledge of, but they do not make conclusions. All right. So if they have a question which calls for a conclusion, or if they offer a conclusion, objection, Your Honor, it's conclusion. Motion to strike. Objection calls for opinion. This officer has not been certified as an expert in electronics. The question asked calls for opinion. Just give me an example. Objection, Your Honor, calls for hearsay. Or, objection, Your Honor, the answer is hearsay. Okay. Now let's talk about the law that's going to be applied in your case and applied against you. Okay. Now, in the state of Michigan, the case law that controls radar is called Ferency. And it comes from a case, actually a case. The guy represented himself as he was a liberal left-wing attorney, kind of a rabble-rouser, been around for years. God rest his soul, he's dead now. But his name is Zoltan Ferency. And now Zoltan Ferency and I wouldn't have anything in common politically, probably. But Zoltan knew there was something wrong with radar, and he went to trial, and his case set in cement what the case law is going to be in the state of Michigan on radar. In your state, wherever you happen to be, there is case law that controls radar in your state, and it's probably very, very similar to the Michigan law, which came together in 1983, I believe it was. But you will not argue fervency if you're in Illinois or Kentucky or Texas. There'll be a case law there. All right, there may be some references within a case law to the fervency case, because this really is a case that really succinctly lays it out in terms of what the state has got to prove in order to gain a conviction or a finding of a responsibility in this civil matter to a preponderance of the evidence. Mind if I take a sip of this? Maybe you want to take a break right now and go to the refrigerator and get something to drink. Why don't you do that? And I'll tell you what, we're going to play something that's kind of fun right here, and we'll be back in about a minute, okay? God bless.
Well, it's Friday night and he's pulling them over left and right. He sort of looks like Darth Vader with his gun and his radar and his flashing blue light. He drives a government squad car full of all kinds of hardware to handle the angry mob. And with his badge on his shoulder and his gun in his holster, he'll tell you he's just doing his job. Watch out for martial law when he's out there watching after you. If he's a tool of the bankster, he's a badge-wearing gangster, an agent straight from Interpol. Watch out for martial law. He's there to prove who owns the muscle and might, and he just might pull you over to the side of the shoulder, 'cause he cannot see your license plate light. Because he cannot see your license plate light. Ain't it a frightening feeling when you're behind the wheel and you see him there? Or when you're rounding the corner and he's right there behind you in your rearview mirror? Is he a foe or a friend, or this public defender we see on our TV screen? Or just some vain reckless power gaining strength every hour, a threat to the American dream? Watch out for martial law when he's out there watching after you. If he's a tool of the bankster, he's a badge-wearing gangster, collector of the revenue. Watch out for martial law. And if he's tailing you, you better not run.
Okay. We hope you enjoyed that little ditty. Everybody all set to go on to the heavy stuff? All right, let's do it. You are, if you happen to be in Michigan, the case law is a case called Ferenczi, People versus Ferenczi. It's located at 133 Mich App, Michigan Appeals 526. That's volume 133, page number 526. This is how these things are laid out. And whatever law book you go to, it'll be laid out the very same way. Whether it's a Michigan court case, an Ohio court case, U.S. Supreme Court case, there'll be the first number is the volume number. That's the number of the book, and then the second one is the page number. I wonder if I got what do I got? Yeah, well, first it's like what do I got here? Got so much junk. Well, here we go. Michigan statutes annotated. Okay, this is another compilation. It says there's a volume number 2. Well, if you were looking for something, it would be volume 2 and then such and such page number. That's how that works. All right. Now, but let's say you're not in Michigan, okay? And if you're not in Michigan, incidentally, in the paperwork package that we offer here, it's got all this stuff. Yeah, it's got the Ferenczi case. It's got a sample of an appeal. Matter of fact, I'm reading from the Ferenczi case that I put in the back of my appeal. This is incidentally a successful appeal, and you don't have to do this very often, but occasionally you will have to do this because you don't always run into an honorable judge. And I had a judge that was just had no regard for the law, so we had to appeal on him. But hopefully you won't have to appeal. We do have a paperwork package that goes with this, and if you purchase this videotape from us, the paperwork's only $25. If you did not buy the tape from us, and you got a copy from somebody's copy of a copy of a copy, or one of those deals, it's $49.95. Okay, and there'll be a little ad at the end of this tape that'll tell you how you can obtain it, and where to send the money to. All right, now let's go to People versus Pharisee, and I tell you what I'm going to do. I'm going to read you what the court said in the People versus Pharisee, which makes this case the law, for lack of a better way of saying this. Now, the reason I said what I just said makes it the law. The law is the common law. James in the Bible said that there's one lawgiver. You know, you hear about these guys in the House Legislature, and they'll say they're making law or they're lawmakers. That's not biblically sound. There's only one lawgiver, and that's God Himself. We who have any sense of wisdom about ourselves recognize what law is, and we obey it. Okay, but law proceeds from God. What proceeds forth from legislature are statutes and codes and ordinances that are civil in nature or contractual in nature. What really happens when you get a speeding ticket? You haven't broken the law. There's no law against driving 65 miles an hour in a 55-mile zone. There's no law. Look in the Bible. Look under common law anywhere. How is there a law against... how is there a damage? See, a law dictates the remedy to a damage that is created by a perpetrator who commits an act with intent, and there's a causal relationship between that act and a damage. A damaged party, a damaged person, a damaged good or an item, as in trespass. That's a violation of the law. Thou shalt not kill, thou shalt not steal, thou shalt not trespass. Okay? How is someone damaged by driving 65 miles an hour? You can drive 65 miles an hour all day long. No one's damaged. Now, if you drive 65 miles an hour in a 25-mile zone, or where any reasonable and prudent person would not drive 65 miles an hour, and you hit someone and you cause a damage, you have committed a crime, perhaps because of your wanton willful disregard of an unreasonable human risk, and your action created a damaged party. Now, that's a violation of law. But to simply drive 65 to 55 is not. What it is, though, is a breach of contract. So if you have a driver's license, then this is evidence that you have volunteered into a regulated enterprise. The terms of the contract are the Motor Vehicle Code, and anything that these boys in Lansing here can manufacture out of their House Legislature that says this is a new code, this is a new statute, this is a new ordinance. The Motor Vehicle Code grows all the time with more and more things. It is presumed that you know all this stuff. If you have a driver's license, this is evidence that you have volunteered to be regulated by this enterprise. And part of the regulation says, thou shalt not exceed 55 miles an hour. If you do that, you haven't broken the law, you've breached the contract. In order to cure the breach, you have to pay some money. Pay some money, breach is cured, you're back in contract with the state again. That's the way that comes down. Now, under the Pharisee case, the judge said, hereafter in Michigan, you can read this right on your screen, in order to avoid any violation of due process rights of a defendant in a speeding case involving moving radar, the following 7 guidelines must be met in order to allow into evidence speed readings from a radar speed meter. All right? Number 1, the officer operating the device has adequate training and experience in its operation. 2, that the radar device was in proper working condition and properly installed in the patrol vehicle at the time of the issuance of the citation. Number 3, that the device was used in an area where road conditions are such that there is a minimum possibility of distortion. 4, that the input speed of the patrol vehicle was verified. This also means that the speedometer of the patrol vehicle was independently calibrated. 5, that the speed meter be retested at the end of the shift in the same manner that it was tested prior to the shift, and that the speed meter be serviced by the manufacturer or other professional as recommended. 6, that the radar operator be able to establish that the target vehicle was within the operational area of the beam at the time the radar was displayed. That the particular unit, 7, that the particular unit has been certified for use by an agency with some demonstrable expertise in the area. Okay? Now those are the 7 indicia, or the 7 elements of the Ferenczi case, which must be met. Now in your state, there'll be a different case, but essentially it'll have the very same stuff. As I go through this case, basically and I don't mean to be insulting when I say this, I'm giving you a reading lesson. I'm showing you how to read the statute and read law, how to read this in such a way that you can then understand how the state applies this as evidence and how you can cross-examine it or how you can win in court. All right? Each and every one of these 7 rules, guidelines, must be met. If they don't meet one of them, it's over. They got to meet every single one of them. All you have to do is just win on one little point. So really, things are in your favor. You just got to find one little weak spot. Knock that weak spot out, and their whole case collapses. And believe me, it's fun. Once you get the hang of this and start doing some winning, it's a ball. All right, now, we have gone over these, read them, and we're going to go over these in detail in just a moment. First of all, there's a great likelihood that you're not from Michigan, so you need to find your case in your state. How do you do that? Well, you start by going, you need to go to your local law library. There may be a law library at your college or your university if they have a law school you may have access to. You might go to your county library, your city library, or you could go right to the courthouse downtown. There should be a law library there that you can gain access to. Now, occasionally we have found people who had trouble getting into those libraries. They run into a clerk, and the clerk would say, "Oh, that's for the judges and the lawyers. If you're not a lawyer, you can't use it." Well, I'll tell you what, that's hogwash. And I'll tell you what you do if that comes down. You just say to the clerk, there seems to be a misunderstanding. You see, my taxes pay for this building, this courthouse, pay for this library. Actually, I own it. As a matter of fact, what is your name? Susie Q? Nice to meet you, Susie Q. You're one of my employees. I'm the employer. You're the employee. I think we've got our statuses a little mixed up here. I want to go into my library and use some of my law books. Now, would you be courteous and kind enough to take me through this door and get me to the library? He says, "I'm telling you, it's only for the lawyers and the judges, and I'm not going to let you in." Say, tell you what, you may not be familiar with Title 42, 1983, but it appears to me that under the color of law, you are impinging upon my right to go into that library. And Title 42 says if there's anybody who infringes upon any right guaranteed to me by the Constitution of the United States, and you do that under the color of law, you're actionable to me for $10,000 a day for every incident, every day that happens. Now, what I need you to tell me is, Susie Q, how do you spell your name? All right. Now, are there any other individuals that I should join in this lawsuit? Because as nice as you are, and I hate to do this, I am going to have to sue you. But I need to know, is there someone else that told you to tell me this? Because if there's 2 or more people, now we have conspiracy. Maybe you have a supervisor or your boss about that time, the conversation breaks down fast, and she'll have somebody else in there. And pretty soon, you know what? You're going to find yourself inside that law library. Yep. I promise you. In fact, we had some... we threatened so many lawsuits, and we went through so much here locally that they moved the library. Instead of in the courthouse, they moved it down to the public, or to the county library. Now everybody has access to it. But I'll tell you, they get this master-slave relationship going, and they think, man, they're really something. They think you're a bunch of idiots, and they're the only ones with brains, and they've got all the power. There are public servants. And we are the masters. They are the servants. We employ. They are the employees. Sometimes you may have to push that issue. I just mentioned this so that you can lay that on them. And by the way, the Title 42 information, we'll put that in the paperwork also so that you have a little bit of help there. You may never need it, but if you do, you got it. All right. All right, let's talk about efficiency here. Number one. Oh, no, wait a minute. We got to get you to your books first. We'll show you this little clip. It's about a minute long. It'll show you the sequence about how to find. When you go into the law library, where do you go to find the case law controlling radar in your state? This is how the sequence goes. This is what we did in Michigan. This is what you do wherever you happen to go. It's the same process no matter what state you're in. Let's go ahead. We'll flip to that right now, and then we'll be right back. All right, now let's say you're trying to find a law. You don't know where to look. Well, in Michigan, we look under Michigan Compiled Laws, the General Index, under motor vehicle, and then the subheading of speed. Under speed, generally, it refers us to traffic rules and regulations. Under traffic rules and regulations, here we go, we find speed 257.626. Now that our index has told us where to go, we find in Michigan Compiled Laws, we need, what, 257.6? Well, it should be right in this volume, right here. So we pull it off the shelf, pop it open, and go to the appropriate page. And here we are, 257.626. Follow down this column. Well, looky here. Radar speed meter evidence, inadmissible. People versus Pharisee, that's the case we're looking for. Note also that it can also be found not only in MISHAP, but 351 Northwest 2nd at page 225 if you have Northwest 2nd volumes. But we're looking for Michigan Appeals, volume 133. So let's pull that down off the shelf. That one right there. Yep. Take her down. And we need 133 MISHAP at what? 526, I believe it is. And there it is, folks. People versus Pharisee, and that's how you find your case. The procedure is the very same no matter what state you happen to be in. Okay, welcome back. I think you're not going to have any trouble finding the particular case you're looking for. Now, what you're going to do with your case is exactly what we're going to do with the Pharisee case right now. We're going to go through this, break it down word by word. We're going to cite the important elements and issues that you need to zero in on. And so let's go for it. It's on your screen right now. Number one, the officer operating the device has adequate training and experience in its operation. The question the prosecutor probably will ask is something as simple as, an officer, do you have training in the use of radar? Yes, I do. And do you have experience? Yes, I do. And how much experience do you have? I've been doing this for 5 years. And they'll go on to the next issue. That's enough to tip the scales on the preponderance, all right? What you'll do is you'll go back and attempt to, find out about the authentication of the training. Where was the training? Where did it take place? Do you have a certificate? Did you graduate? I will tell you ahead of time. This is one of the easiest parts of the case for them to establish, so I wouldn't worry too much. I never worry about this portion of the case. All right? There's 2 or 3 other areas that are real weak links. Just go for the weak links, okay? Point number 2. The radar device was in proper working condition and properly installed in the patrol vehicle at the time of the issuance of the citation. What the officer will testify to is that he went through the checks that the manufacturer recommends for for lack of a better way of saying it, kind of a surface check. They turn the unit on, they test it with an internal checking mechanism. If the lights come on, if everything's cool, It's working. And they'll do that several times a day, and they'll testify they do that several times a day. That will satisfy the judge that the device was in working condition. All right. Now, the key question here is proper working condition. You can hammer on that if you want to in terms of the electronics of it. Don't miss the part that says, and properly installed in the patrol vehicle at the time of the issuance of the citation. You want to ask them, did you bring the instructions with you that detail how to install a radar unit? The answer almost always is going to be no. So then any testimony he gives regarding the installation is going to be hearsay, or from a standpoint of his not being the person who did install the unit. Okay? If you don't have the instructions as to how to install it properly, the key word here is properly. I mean, anybody can install a unit. You know, you could take a guy off the street and say, here, install this in a car, and they could probably do it. But the question is, was it done properly? So many inches from, electrical fans, and so many, degrees and angle here, and put in with certain kinds of screws and whatever, okay? All that data is included somewhere in the manufacturer's recommendations for installation. There would be templates involved and all that sort of thing. They're not going to have that stuff. And so then you simply ask the officer, then you really don't know then, do you, if it was properly installed? And, bring them down a little trail where they have to make an admission that they don't know what the proper installation is. I had an officer do that. It was beautiful. I just said, did you install it? No. Do you know who did install it? No, I don't. Do you have the instructions for the installation? No, I don't. Boom. No testimony. They lose. All right. Number 3, that the device was used in an area where road conditions are such that there is a minimum possibility of distortion. All right. Now, in your paperwork package that we send you, there's a lot of detail about what some of these distortion factors are, such as the cosine batching error, the shadow error, the ghost readings error, and so on. And the fact that, for instance, ghost readings are readings displayed by the computer module where no vehicle is in the operational beam area. I mean, I'm quoting right here from the Ferenczi case. These things display readings, ghost readings, when no vehicle is present in the beam area. These readings may be caused by electric fan interference, radio transmissions, neon lights, other extraneous factors, both inside and outside of the patrol vehicle. All right? And so the question I like to ask is, officer, you're not God, are you? No, I'm not God. You don't have X-ray vision, do you? No, I mean, you can't see through the ground, can you? No. If there were power lines that were underground and in the vicinity of where this incident took place, you would know that, would you? You don't know what's happening inside the houses nearby this area, are you? He said, well, what do you mean? Well, if there was a ham radio operator inside one of the houses who was keying up his transmitter, 1,000 watts of power, at that very moment, you wouldn't be aware of that, would you? I mean, you've just testified you're not God. You don't have omnipresent knowledge. You've testified that you don't have X-ray vision. You don't see through the ground. You don't see through buildings either, do you? No, sir, I don't. So if there was that type of activity taking place, you wouldn't know that, would you? If there was an airplane at 50,000 feet flying over and using radar frequencies for its altimeter flying over at that moment in time, you wouldn't be aware of that either, would you? I mean, can you see 10,000 feet or 10 miles up through the clouds? Can you, officer? No, I can't. So you wouldn't be aware of that. If there were satellites circulating over the Earth and sending down radar frequency beams at this very same time that we were passing each other, you wouldn't be aware of that either, would you? Bear in mind, you've testified you're not God. You don't have omnipresent knowledge. You don't have X-ray vision. When you're driving down the road, you're not looking straight up in the air, are you, officer? No. So you wouldn't be aware of that, would you? No, I wouldn't be aware of that. And so you bring them down to the place where there's the possibility of all kinds of extraneous outside interferences that could come into play here, and the officers testified over and over and over, no, that he would not necessarily be aware of these things. So then you just ask the question, so officer, you can't really testify to this court that to the exclusion of all possible interferences, that there was no possibility of interference, can you? All right, see what he says. You'll get a variety of answers. But that's the sequence you do when you do your cross-examination in order to create the possibility that there were, and particularly his confession on the witness stand, that there may have been a possibility of distortion. All right. Now, quite frankly, we're still not at the weakest link in their case here. So don't feel bad if you don't necessarily feel like you established this, you know. Number 4, that the input speed of the patrol vehicle was verified. This also means that the speedometer of the patrol vehicle was independently calibrated. Here is the weak link. Matter of fact, this is probably the weakest link in moving radar. Now, the way radar works, let me quote you directly from the Ferenczi case here. And again, this is in your paperwork, but I'm going to quote this. Verification means that the radar unit is not sufficient. What this means is that the radar unit itself has a feature where it tells the forward speed of the vehicle as it's going down the road. The radar signal comes out of the antenna, and a portion of it hits the ground right in front of the car. That portion is internally read by the radar unit and interpreted as miles per hour. Okay? As part of the checking of the radar accuracy that the officer does is this internal check where he'll say, if the radar unit shows 53 miles an hour and my speedometer shows 53 miles an hour, then that is an indication that it's working accurately. Okay? But it presupposes that the speedometer is also accurate. Just because they're both coincidental in the numerics doesn't mean that it just means that they agree. If the speedometer is off and the radar agrees numerically with the speedometer, well, that means the radar's off. But it wouldn't necessarily be apparent, would it? And so Ferenczi says the input speed of the patrol vehicle has to be verified. That means the speedometer has to be independently calibrated, independent of the radar unit. As we continue on here, the verification of the radar unit using a speedometer not independently calibrated is also not sufficient. Both amount to bootstrapping the accuracy of the unit. The interim guidelines require independent calibration. In testing a moving radar unit, the patrol car's speedometer is measured against the digital display of the low radar. When this low radar reading and the patrol vehicle speedometer are the same, the radar is said to be operating accurately. Criticism. Automobile speedometers are not inherently error-free. Authorities estimate the margin of error at about 7%. When the vehicle's tires have been changed to either a smaller or larger size, the speedometer must be recalibrated. Otherwise, the vehicle speedometer fails to measure the true speed of the vehicle. When the speedometer of the pace vehicle is malfunctioning, or there has been a tire change without subsequent recalibration, an error in the radar unit may go undetected if the radar's error is identical to the speed, the speedometer error. All right. So let's say, for instance, that they just happen to have a certificate of the calibration of the speedometer. Check the date on that calibration certificate. If it's from a year previous to that, then ask the officer, can you testify to this court that the tires that were on that vehicle on the day that this incident came down, can you testify to this court that those are the very same tires that were on there when this calibration was done? Either way, you're going to win on this one. If he says, yeah, it's the very same tires and there's been 6 months that went by, the diameter of those tires has changed because there's less rubber on them. And therefore, it would change the rotation, the speed rotation of the tires in relation to the speedometer, which would have changed the calibration of the speedometer. If he says, no, there's new tires put on, the interim guidelines dictate that there must be a recalibration every single time those tires are changed. So, here you go. You can win on this particular issue, but I'll tell you what, the easiest way to win on this one is the fact that they won't have a certificate with them of independent calibration. This is the weakest link. They lose all the time on this one, where there's people who know enough to raise this issue and make this argument. All right? On to number 5. That the speedometer, that the speed meter, that's the radar unit, be retested at the end of the shift in the same manner that was tested prior to the shift, and that the speed meter be serviced by the manufacturer or other professional as recommended. The first part of 5 is fairly easy for them to establish because the prosecutor will simply ask, hey, did you test at the beginning? Yes, I did. And did you test at the end? Yes, I did. And what did you do when you tested? And they'll tell what they did when they tested, and they'll satisfy the judge on this one. But the fact that the speed meter must be serviced by the manufacturer or the professional as recommended is an extremely weak area for them to establish. Most of the time, they will not have the manual with them. Just ask, say, do you have the manual with you which gives the recommendations by the manufacturer for servicing? No. Now we're back to hearsay statements about what these recommendations might be. I've had some very honest answers from officers, by the way, on this, and they simply said, don't have the recommendations, don't know what the recommendations are. Ask them, has the unit ever been serviced? And we had one case where the radar unit had been in service for 3 years. Said, has it ever been serviced in 3 years? No, it has not. Man, the argument to the judge is, Your Honor, Pharisee requires that it be serviced. I mean, everyone who's got a VCR, there's recommendations on servicing VCRs. There's recommendations on servicing automobiles. There's all kinds of service recommendations by virtually every manufacturer of anything going down the line. What are those service recommendations for radar? If you don't know what they are, you can't service it. And in my case, the officer who testified had never been in service. So there's an area right there. Circle. That's a good one to go for. Number 6. Radar operator be able to establish, the key word here is establish, that the target vehicle was within the operational area of the beam at the time of that the reading was displayed. Now, here's something that you're going to see up on your screen right now, and I'm just going to refer to it at this time. Notice how this is an illustration of the police car, the radar beam coming out there at 18 degrees width, and in this case we've got a semi rolling down through there. This is what we're talking about establishing. It's not just a matter of, and a typical prosecutor will ask on direct examination, they'll say, officer, did you determine that the subject vehicle was within the beam? They'll say, yes, I did. And they may say, and approximately how far away did you first notice this vehicle? And they'll give certain numbers of feet, or maybe a quarter mile, or something like that. And were there any other cars present? No, there were no other cars. And so the subject vehicle was within the beam. Yes, it was. That is not, and now that will satisfy the judge to a preponderance of the evidence, unless you go in and whittle this down to fine details. In the case of Pharisee, they certainly did this, and I'll quote you directly from Pharisee. At trial, Officer Flory testified that US 27 is a 4-lane highway with a center median. The lanes are approximately 12 feet wide, and the median is approximately 35 to 40 feet wide. Officer Flory was traveling in the northbound passing lane when he first observed defendant traveling in the southbound passing lane at what appeared to him by visible observation a speed in excess of the speed limit. Using the Decatur MV-715A unit installed in his patrol car, the officer determined that defendant was traveling at 67 miles per hour and the patrol vehicle was traveling at 53 miles per hour. The officer's initial observation of defendant was at a distance of 750 to 900 feet. The officer observed defendant's vehicle for 4 or 5 seconds before operating the radar unit. In his defense, defendant called Dr. Dennis Bride, a law enforcement specialist with Michigan State University. The trial judge allowed Dr. Bride to testify as an expert on the use of radar. Dr. Bride testified that the width of the radar beam is approximately 18 degrees. Using the figures supplied by Officer Flory, Dr. Bride computed the closing speed between the two vehicles to be 120 miles per hour or 176 feet per second. After the 4 seconds, the vehicles would have been 196 feet apart, 900 feet less 704 feet. After 5 seconds, they would have been only 40 feet apart. At neither of these distances would the defendant's vehicle have fallen within the radar beam from Officer Flory's unit. Now, if you're comfortable with mathematics, and depending on the officer's testimony about the distance and the speed and the closing speed and all that, be prepared and do some practice on this to calculate these dimensions and force the officer to either show that you were within the operational beam, or, in this case, you couldn't possibly have been within the operational beam. You can see that in this case, I think the Officer Flory flubbed up when he gave these figures of 750 feet to 900 feet. With a closing speed of these two vehicles approaching each other, you're going to cover 900 feet pretty fast. And so that guy kind of shot himself in the foot. The same way the officer evidently shot himself in the foot here with these dimensions. You can do the same thing if you talk at the make a mission confession about where you were, where the officer was, and you know, all these sort of things. These things will come back to haunt you. And no doubt this has haunted Officer Flory ever since this case came down. But the officer must be able to establish that the target vehicle was within the operational area of the beam. Number 7, particular unit. And notice this says particular unit. You're going to be able to establish what that radar unit was because, remember, at the scene of the crime, you're going to take your little tape recorder and you're going to go back to that officer's car and you're going to get the serial numbers off of that unit and give a positive identification on that. Also, the officer's badge number. You want to be able to ID all this stuff. You don't want them to come into a court and bring documents for a radar unit that was not this radar unit and somehow bluff the court and win this case to you. No, you want to make sure that you're pressing the issue on this particular radar, that the particular radar unit has been certified. What does that mean? It means they've got to have a certificate with them in order to prove that it's been certified for use by an agency with some demonstrable expertise in the area. Some people have that with them. If they have certificates with them of any kind to certify either, to satisfy either number 7 or to certify that the speedometer has been independently calibrated or anything else, then what you do is you attack the authentication of the certificate evidence that they attempt to offer, and you will seek to suppress that. This material is in the paperwork that you get with this, if you with this tape. Incidentally, if you didn't get any paperwork with this tape at the time, all you need is proof of purchase of this tape, and you can have the paperwork for $25. If you don't have proof of purchase, the paperwork is $49, and it's obtainable from us. Okay? Actually, with the videotape, you are going to be, just videotape alone, you're going to be so prepared as compared to what these guys are used to rolling over in these courtrooms. But with the paperwork, you know, for those who want to make sure you've got everything right, tucked right down there, and plus some other information about cross-examination. Here's a portion of our paperwork which has to do with cross-examination and objections to be raised. Okay, I don't know if you can see this here on this screen, but let me just go ahead and cover for you a few of these things that are covered. Narrative objections, leading objections, argumentative objections, assuming facts not evidence, you've heard me mention that, compound questions, ambiguous or unintelligible questions, speculation, asked and answered questions, mistakes of evidence, oppressive and harassing questions, and non-responsive questions, just to mention a few of the objections that you would be able to raise. We include that in the paperwork. Okay. I want to mention here that preparation is the key. You're going to be prepared when you go into court because you understand a little bit more today about radar, how it works, how to examine, how to cross-examine, how to ask questions, how to do a reading lesson. Okay, now, again, if you're not in the state of Michigan, you're going to use another case. We showed you how to find your case law in your state. Break it down the very same way that I just did the Pharisee law, okay? And you're going to have fun with this thing. Preparation, to me, comes in 3 areas. First of all is the knowledge. If you've got it up here, you know basically what you need to do and what's got to be done. You've got the knowledge. Then you need to prepare emotionally. Okay, you need to be up for this case. You need to get psyched up for it. Okay, and in getting psyched up, I want you to. It's just like an athletic contest. Go in there with the idea that I'm going to win this thing. I'm going to not be intimidated by the judge. Now, the first time into court, the whole atmosphere is quite intimidating. And you may kind of get a feeling like the EBGBs run up down your spine. You're a little bit nervous. One of the ways to dispel that is to find some time where you can go down to the courthouse and sit in and observe some trials and process. There's a docket that will be out in the hallway somewhere that lists the various cases that are taking place every single day. Try to find speeding cases or traffic cases where you may be able to sit in and see the actual prosecutor or one of the prosecutorial staff members who will be coming against you and see the way the questioning goes, the kind of questions that they ask, and then think to yourself, now what would my objection be here? Did they ask a leading question? Did they assume facts that are not in evidence? And at this point, I'd object, wouldn't I? And kind of role play that, and you'll get kind of familiar with the way things flow, okay? This is part of being prepared emotionally so that you're not nervous and uptight when you go into court, all right? And then get spiritually prepared. You know, if you're a Christian, you should pray about this and ask God to help you to be mentally alert and to ward off the spiritual entities. The Bible says that we wrestle not against flesh and blood, but against powers and principalities, the rulers of the darkness of this world, spiritual wickedness in high places. I'm going to tell you something. Around these courthouses, around our where we come from, we call them the synagogue of Satan. There is so much bad stuff that happens in these courtrooms, so many dirty deals that are cut, so many bad things that are done to people by these people who would be gods, who sit on these benches with their pious black robes, and they many times play God with people's lives. Don't get me going. This stuff amounts to spiritual wickedness. And so there's a satanic element involved here, and it's just plain evil. And so you need to be spiritually up for this. Otherwise, there are some spiritual things that come to play here in my mind that work against people simply trying to obtain justice. And if you read the Bible, cross-reference in your Strong's Concordance, you'll find a lot that the Lord had to say about justice and judgment and doing things right and treating people right. All you really want when you go into court is get a fair shake, don't you? And so anyway, get prepared mentally, emotionally, and spiritually to go in there. Now, let me say something here about a score sheet. What is a score sheet? A score sheet is where you can either type this up or Xerox a copy of the like disparity, the 7 points of efficiency, Xerox that real big, and then go through, and what I do is I put circles next to every key point that the prosecution has got to establish. When they do their direct examination, I simply go through and I check off. If I feel like, well, they pretty much established that, I check them off. When they get done with their direct examination, if there's places that I don't have a check mark, it tells me they didn't cover those areas. Over half the time, you will not have to ask the officer any questions. You certainly won't have to put on any kind of defense yourself, because if they omit something, they lose. And if for some reason, if they're in a hurry or you've skillfully used a lot of objections, you kind of got them mixed up a little bit and they miss something, seize the moment. Don't ask any questions. Don't cross-examine. Tell the judge as soon as their side rests that you're ready to go to final argument, and zero right in on that point that they missed, and bring it clearly to the attention of the court. Your Honor, on the matter of the servicing of the unit by the manufacturer's recommendation, they didn't even touch us. Not one word of testimony about servicing, Your Honor. I move this case be dismissed. Failure to present a prima facie case. You win. Yep. It's the way it works, all right? Another way that you might be able to win without even going to trial is to go to the police station and obtain a copy of their current FCC license to operate these radar units. If it's expired, bring it to their attention and say, you mean to tell me you're collecting all these revenues, millions of dollars worth of revenues, with radar units that aren't even federally licensed? You guys have a duty to do that. And tell them you're going to put together a class action lawsuit and get these millions of dollars back for all these people. That can win too. Also, you may find, let's say you're being charged with driving 100 miles an hour in a 50-mile zone. That's a hefty ticket, a lot of points. You may be able to plea bargain, and you might be comfortable with this. You go to trial or get halfway through the trial, okay? And maybe you're clearly not really winning, but you're making trouble for the prosecutor, and they're getting frustrated. They want to go home. The judge wants to go home. Just tell the judge, Your Honor, could I confer with Mr. Jones here, the prosecutor, for a moment? And just tell him, say, look, are you ready to plead me down to 60 and a 55? And I'll take that plea, and we can all just go home. I feel like you want to go home, and the judge is getting tired. I'm getting tired too. If you'll do that, we'll just settle it right now. And you might be happy pleading 60 and a 55 as opposed to 150 or something. Okay, so there's always that possibility too. All right, we're kind of down to the end of time. I hope this has been helpful. You can win, folks. Just break down your case. Get a score sheet together. If they don't establish every element, go for the weak links, and you're going to be a winner. Believe me. All right? God bless.
I had this crazy dream about some folks who love this country, who all began to dream the same dream. And when the morning came, there arose across this nation people thinking one and the same. And they awoke to find their freedoms and all their liberties had gradually been taken away. And when they realized the danger to their posterity, I heard those patriotic people say, we want this country back. We ain't just joking, Jack. We want our liberty and our dignity and our freedoms and